What's up, everybody? Last minute live here. Oh, one of my lights is not on. I'll fix that in a second in case it looks a little dark. But I was planning on just recording this during lunch with my dad because a bunch of people had questions about a hearing yesterday, I guess, in Karen Reed's case. But to preface this video, I do not know all the facts, all the ins and outs. I have not done deep dives on Karen Reed's case purposely because people are saying it's supposed to go to trial in March, and I want to go into that trial not knowing anything about the case. All I know basically is Karen Reed accused of hitting her Boston cop boyfriend and leaving him out in the cold, and she's charged with that crime for taking his life, and that she says it's a massive police cover up. That's basically all I know. But what we're going to be talking about today is the allegations from her lawyers that the prosecutor's office is being investigated federally and what that means, what that looks like, and if her defense attorneys are going to be able to use that in the trial for her defense. Because you would think that if there's some kind of federal investigation where there's smoke, there must be fire, and therefore there's probably going to be so much that they can use in their defense. But is that the case? And then there's also reports coming out now this morning from the prosecutor's office that the defense attorney completely misrepresented that and that their office is not, in fact, under investigation federally. So I know a lot of you have been following this case. I got a ton of questions on it. I'm doing my best to not watch a lot on it and not get a lot of the facts from both sides and what's being reported in the media so that I can just see what kind of comes out in trial. And we can see if, based off the evidence presented in trial, did the prosecutor prove this case beyond a reasonable doubt? Or are we going to see some cover up? Are we going to see some facts come out? Because there's also some notes going back and forth potentially that they discuss here that might come out and affect this trial as well. So there's nobody better to help me break this kind of a question down than my dad, who was a former federal prosecutor. He was the chief of the criminal division in the Middle District of Florida. He made these types of investigative decisions for the feds and charging decisions for the feds when they were going to investigate certain crimes like this, when they were going to charge them, what it means to be under investigation, because it's not the same thing to be arrested or indicted, just to be under investigation. And then he's obviously been practicing criminal defense now for 30 plus years on the other side, dealing with the issues that Karen Reed's defense attorneys are dealing with now. So welcome in, Father.
Hello. Good morning.
How are you?
Good. It's still morning? Yes. No, it's not.
No, it's not.
Good
It's
afternoon.
the lunch hour here. It's the lunch hour. Oh, and by the way, I meant to say this off the top. So we were planning on just recording this during the lunch hour. Instead, I was like, why don't we just go live? Right? Let's just go live. We have a live planned later today to talk about Chad Daybell, which, Dad, I think you'd have an interesting take on that as well. His lawyer wanted to withdraw and the judge said no, which is always funny. People are like, what? Judges can do that? We're like, yeah, it happens all the time. But that's for later. I think 2:30, 3 o'clock later on today. After I do some more work, I'm going to do that live. But I wanted to come on here, and instead of just recording this and playing it later, I figured we would do it live so we could answer some people's questions as we go. But the first thing I want to ask before we watch the hearing, because we're going to watch the first 15, 20 minutes of the hearing and kind of break it down together. But when federal prosecutors are investigating you and there is a quote unquote formal investigation, do they have to tell the target of that investigation that they are in fact under investigation?
Well, the simple answer is no, but I want to step back a minute and explain that not everything they do is an investigation. They have a technical term called a matter, where they'll open something, they'll say, okay, we'll make this a matter that has gotten our attention, but it might not be worth doing anything. Let's just kind of scratch the surface and gather some information and see whether or not it's worth doing anything about. So my guess is what's happened here is this is actually a matter. A lot of people call it an investigation, and they would call it an investigation, but the department may refer to this only as a matter.
Right. So, and that's why there can be some semantics where lawyers would love to use that saying, oh, that is not true. We are not under investigation, but it could be a matter like you're talking about they could be looking into. And the defense attorney, again, using it to their benefit, calling it investigation, because out to the public, that obviously looks a lot worse. Have you been in situations where you've investigated other prosecutors, governmental bodies, law enforcement, things like that?
Oh, absolutely. And I have represented governmental bodies that have gotten what we call information requests. Well, they'll send a letter like what may have happened in this case, saying, would you please send us this information, or we'd like to know this kind of information. And so they're gathering the information. I've also done the same thing. I will send letters to a governmental body or to a prosecutor. We have looked at prosecutors' offices when I was at the U.S. Attorney's Office, state prosecutors, and we'll say, we would like to take a look at this. Would you please send us this stuff? And this is something that precludes grand jury subpoenas. My guess that hasn't happened yet in this case. They're talking about letters, so my guess is these are requests for information.
Yeah, and we're going to get to the letters now when we watch the hearing, but just this stuff does happen. I hate that view. How do I change it? There we go. This stuff does happen. It's not completely unheard of, but it's usually, let me knock the speed down to not Peter speed. Usually it's not a good thing, obviously, for the prosecutor if they're being investigated, specifically dealing with their prosecution investigation on this case. So it's obviously a negative if it is. What?
I'm sorry. Go ahead. I didn't mean to interrupt you.
No, go ahead.
No, there must be something there, because in order to get the attention of the U.S. Attorney's Office, somebody must have given them something that causes them some concern, because they get complaints from citizens all the time, and especially when they're dealing with a state prosecutor. So there's something there that they want to look at.
Right. And again, when you say there's something there, it could be as simple as something that doesn't smell or look right at first glance, that after further investigation, it actually is fine. So just because they do an investigation doesn't mean there's something there as far as criminal activity goes. All right, let's take a listen here. This is the prosecutor who's going to start, and then we'll hear from the defense attorney who's appearing via Zoom.
Any of these materials pursuant to statutory, pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order impoundment was appropriate, pursuant to the case law, and would ask that the motion be allowed.
So again, it kind of started in the middle, but their argument is basically this is an ongoing dealing with grand jury stuff, and grand jury stuff must be protected. Therefore, we want this correspondence between us and the federal prosecutors to be protected, just like other grand jury discussions are protected. Basically, that's the prosecutor's argument here. Now, there's going to be a response from the defense, but that's basically what the prosecutor's trying to say. We've talked about it in Koberger and other cases about how the processes of a secret grand jury must be sealed or confidential, not public record.
All right. And just so we're clear, because you referenced it, I did receive, as you're all aware, correspondence.
By the way, people asking what state this is in, if you just listen to the judge, you can tell what state it's in.
She's got a great accent.
It is. It's so good. It's like from a movie.
Yeah.
It's from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion.
So before we get to the defense attorney's argument, the U.S. Attorney's Office, the department in Boston wanted to make sure the court knew they don't think this stuff should be confidential. They don't have an objection to the public disclosure of these letters, of the correspondence between the U.S. attorneys and the state attorney's office. How unusual is that, Dad? That two prosecutors, right? You would think they're on the same side of the law. They both want to get the bad guy, but the feds are saying, we don't think this stuff needs to be blocked from the public. And the state is saying we do.
And that's a real clue to what's going on here. Because if it's something that, if the prosecutor is the U.S. Attorney's Office is trying to keep whatever they're doing secret, they would sure have an objection. I appeared there's a lot of times I've appeared in a state court to protect a federal investigation, but they don't even show up and they don't even care that this is going to become public. So that's a real clue. And also that really hurts the prosecutor's argument that this is grand jury material. Because what does this have to do with a grand jury if the U.S. Attorney's Office doesn't even care if it gets revealed?
And the U.S. Attorney's Office would also want to protect that grand jury information.
Sure they would.
Yeah.
Sure they would.
And like you said, if they were on the same side, they'd be showing up their united front, but they're not, which I think is really, really interesting.
Mhm.
So with that, I'll hear from you now, Mr. Yannetti.
I appreciate
So now we're about to hear from the defense attorney, Karen Reed's attorney.
that. Thank you, Your Honor. May it please the court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order,
Just so it's clear, I have not seen those letters.
So I'm going to skip a little bit here because there's some back and forth about whether the judge should read the letters. They hand the judge the letters, and then he starts his argument again. So let me skip forward. He talks about the 2 reasons he's going to try to get these letters public, but let her read them here first. And then prosecutor, she's like, who's got it? He's like, it's the prosecutor's motion, or the Commonwealth is what they call them, instead of the state or the district attorney's office. So she gets the letters, judge reads the letters, and then she eventually tells them, okay, we're ready to go. All right.
I just have 2 more to just quickly take a look at.
And these are, again, letters between the state prosecutors and federal prosecutors that the state wants to block, the feds don't care to block, and the defense definitely wants them publicly disclosed.
If you want my guess, the U.S. Attorney's Office is asking for some of the grand jury material.
Right. But
Yes.
just because they're
Yeah.
asking for some of the grand jury
Right.
material does not make it protected grand jury information.
Absolutely not. But I bet you that's what they're asking for.
Yeah, I have no idea. But it's just interesting. It's just interesting when prosecutors want stuff blocked. You know, it's always interesting. If the defense attorneys don't want it blocked and the feds don't want it blocked, it's strange to me that the state prosecutors want it blocked unless it's bad for them. I mean, that's the only thing. It's like when we have a premises liability case and there's video evidence, you know, at the bar or at the hotel or at the store where something happened, and they don't want to turn it over to us. It's like, well, that's probably because it's bad, because every time it's been good, they turn it over to us like that.
So I'd also like some time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them? Paragraph, the second full paragraph. I'm not going to allow you to reference that right now.
So as she's reading it, she's basically saying there are some parts I don't want you to reference in your argument, because the defense attorney was saying, I need to reference some of these letters when I'm making my arguments to you.
If I may, the letter may be visible on the Zoom screen.
See through it? Because I've got the print facing me.
You could see a portion of the print, that's all.
Okay.
The angle.
All right. Those parameters, Ms. Giannetti, I will let you
All right, here we go. Now we get his
I
argument.
will let you reference the subject matter of the others.
Okay, that's fine, Your Honor. So in terms of the 2 parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case, because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance.
So the defense has filed a motion for sanctions against the prosecutors, seemingly about this stuff. Again, I'm not going to deep dive into these facts until the case actually goes to trial for this case. But he's basically saying, in order for me to make those arguments publicly and oral arguments at that motion for sanctions, I'm also going to need to reference the contents of these letters.
So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary.
So he's basically reading a standard that these letters could be blocked from the public if they were discussing policy decisions like trial strategy, but that's not what we have here. He's basically saying they could be blocked, but they don't have those facts here.
These letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation.
Okay, so we'll start with that. And again, the state attorney has come out and said, or the Commonwealth has come out and said, some of this was misrepresentation. There's not under investigation. But one of the letters, at least, is the state asking for the feds to release information about their investigation. So what does that tell you?
Well, it tells me that one of 2 things. One is the district attorney's office is trying to protect themselves and find out what the U.S. attorney's office is doing, or the U.S. attorney's office has developed evidence in the case, and the evidence they've developed is not something the district attorney has, and they want the evidence of the case or of the murder that the U.S. attorney's office or federal authorities have developed. I mean, it could be that they
It doesn't necessarily have to be investigation about the Commonwealth.
Right. It could be something that they want in the case itself. Like maybe the FBI lab developed something in the case that the district attorney's office could use in the prosecution of the case. Could be one of those 2 things.
Welcome, Verena, to the membership crew. Angela said, what if they don't send it or say we don't want to send it? I don't know if they're talking about, so the feds can usually say no to the state, not the other way around.
Yeah, we had a federal judge that used to say, a federal judge can get you out of state prison, but a state judge can't get you out of federal prison. And that means that the federal authorities are supreme. If the federal authorities thumb their nose at the district attorney's office, there's nothing they can do about it.
Category 2 are 4 letters back and forth between the Norfolk DA and other agencies, wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation.
So there, the second category. So he's giving like the categories these letters fit into. And he's saying the second category of letters are saying the Commonwealth is basically saying to other authorities that the U.S. Attorney's Office should be taken off this investigation. Now, to me, that sounds like they're talking about the Karen Reed investigation, that they want to get the feds off the Karen Reed investigation. So again, that could mean don't step on our toes. It's not unusual we've all seen it in movies and we've seen it in real life where the state is annoyed at the overarching feds, whether it's state police and FBI or state attorneys and federal prosecutors. So that could be a plausible explanation, or they don't want somebody looking over their shoulder, right?
The only person that can take the U.S. Attorney's Office off an investigation is the Attorney General of the United States or the President. So I can't wait to see these letters because I've never seen a district attorney write a letter like that. So
yeah, or the U.S. attorney there could take himself off the case if he wanted to. Like
it doesn't sound from the way he's interpreting it. It sounds like they wrote a letter to somebody else to take the feds off.
We'll see. Yeah, we'll see. I don't really know. It's a little bit vague, to say 4 letters, say something you can say in 1 line, but I'm interested to read them too.
And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI, asking him to have his agents speak to the state police who are under DA Morrissey's command.
So again, that can sound nefarious, or it can be about the Karen Reed case to collaborate, right?
Right.
Clear. There is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect
So if that's the case, do you think it's proper for the defense to file a motion for sanctions against the prosecutor for trying to block stuff and saying it has to do with grand jury proceedings or policy discussions when really none of that's in there?
Well, there's got to be, in order to have some kind of an effect, there's got to actually be something concrete. And, I don't see anything concrete here. It's got to affect the rights of the defendant. And even under his interpretation of what's being said here, I don't see whether the defendant is being prejudiced by what's happening here. Again, there's just so much we don't know, but it's bizarre. The bizarre overarching
Theme.
comment here is it's bizarre that a district attorney's office is fighting to keep these secret. That's the thing you've really got to wonder.
Right. If it was just them saying, hey, FBI, can you give us the DNA lab results that you had? Or can you have your investigator talk to my investigator about the interviews you guys did so we can really try to catch this bad guy? Why would they want that stuff sealed? It wouldn't make sense.
I know.
Ashley said, so happy you're covering this. Papa T, hi.
How are you?
And Danielle and a bunch of other people I see in the chat that have been sending messages on social media asking to cover this case. We are going to cover it kind of from the outside, some of the interesting issues like this, but I don't want to get too far into the facts because I want to walk in as clean slate as I can into this trial. Love, thank you for gifting 20 memberships. Just a random last minute live. You just always got to turn your free gifted membership stuff on because you never know when they're going to get gifted.
that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like.
He's also trying to get the prosecutor kicked off the case, which no surprise there.
That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case.
So, I mean, he said that about as clear as day, that the DA is the target of a federal investigation in this case. And they made some response publicly today, right?
Well, I'm sure that's an exaggeration because number one, the state attorney's office, district attorney's office has denied that and said that no one's ever said that. The U.S. attorney's office never, I mean, I can say never, with rare exceptions, do they ever disclose the target of an investigation. And thirdly, the U.S. attorney's office has very strict guidelines about what a target is. And someone gets what's called a target letter only if they're subject to a grand jury subpoena. And if they're subject to a grand jury subpoena, they're labeled a target. And there's a very strict definition of what a target is. So my guess is there's no target wording in any U.S. attorney's letter to the district attorney.
Which would allow the DA to then come out and say, I am not the target of a federal investigation because he did not receive a target letter
Right.
officially.
Right. That's an official letter. I mean,
Right.
it's in the U.S. Attorney's Office guidelines of what a target is.
Those letters prove that he knew that, even before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor,
Even before they confirmed an investigation, which means now they have confirmed investigation. And it's interesting. I mean, for a lawyer to go so hard to say these letters prove something, he wants them to be public. No, thinking they are going to go public, it would be weird to exaggerate or lie about what the letters contain.
Well, I think maybe he wants to make inferences from what the language is in the letter.
Reasonable inferences.
Yes, reasonable inferences
Yeah.
from what you can read into the letter.
on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not.
So not only has there been a federal investigation on this case, but it is ongoing. So that is kind of vague. A federal investigation on Karen Reed or a federal investigation on the prosecution, law enforcement, how it was investigated, how it was handled. Right?
Right.
I mean, those words that he said could mean either.
Right.
Not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please.
What are you laughing? It doesn't necessarily mean that.
Absolutely not.
But I will say the defense could be thinking, like we've seen some of this in the YNW Melly case, a different office, the FBI coming and looking at this case now could uncover issues with the prior investigation, could uncover some cover-ups or things like that, or some slop jobs like in Melly where they were like, wow, this reconstruction of this shooting was horrible. One of the worst I've ever seen, a different law enforcement officer said about a prior law enforcement officer's investigation. So even that could potentially be scary or bad for the DA's office or something that they're worried about. But I don't necessarily, we weren't on the call and we haven't read the letters, but even just the way he said it does not necessarily confirm that they are a target of a federal investigation.
Absolutely. And again, the word target is a word of art. And I guarantee you that word was not used on the phone call.
Consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions.
All right, so let's talk about this for a second. When something like this is going on, an investigation, letters like this, how much can actually be used by the defense team? He says they're going to use it for sanctions, their public motion for sanctions, but how much of it can be used for that? And then in the future for trial, even if, nothing comes and they're just the target and there's an investigation, what can you use and not use as a defense in trial?
Well, first of all, there's got to be a nexus. There has to be a connection between what's happening to Ms. Reed in her prosecution and what's in the investigation. Is the investigation affecting the prosecution? Are they prosecuting her just because there's an investigation? Or are they continuing to prosecute her because of the investigation? There's got to be a connection. Just because there's an investigation with no proof, no conviction, no evidence, you don't need evidence to start an investigation. That alone does not cause any grounds for sanctions or any grounds for any kind of action by this state court judge against the prosecution for Ms. Reed. Again, just because there's an investigation that means nothing. There's investigations happening all the time. We see it in the press all the time.
And it's just like you can't use an investigation against somebody else, a defendant, a witness. It's like just because you've been investigated for, let's say you've been investigated for theft in the past. I can't say, well, you remember that one time, Mr. Tragos, the cops were looking into you. So you can't use that. It's inadmissible. So you wouldn't be able to use it, quote unquote, against the state attorney's office. But are there aspects of this that may come out as a response to this that can be something the defense can use at trial?
If they can prove that the state or the district attorney's office is doing an action against their client because of or as a direct connection to the investigation, then they may be able to use it. But they have to show that connection, and that's very tough to do. Let me, it's, if I can, let's say, try to think of an example. Let's say the district attorney's office hides a witness from the defense because they don't want that witness to be interviewed by the FBI in the federal investigation. Maybe that can come up at trial. Something like that. There has to be a direct connection to the investigation.
Or if there's a, FBI report that says we found these two witnesses that the state attorney's office should have found or didn't find or purposely didn't want to talk to, or they basically find a mistake that was made by the state attorney's office that any competent investigator or state attorney's office would have done, and they didn't do that. The defense could try to use that as part of their argument that there was some cover-up.
Sure. All right. The state lab developed this. The FBI lab developed a different result from the testing.
Right.
Right.
So there is some stuff that can be used, but just the fact that there's an investigation, or even if they are the target of investigation, is not really enough to be used at trial at this point. Cherry and Max said, Peter, can you please do a quick summary before you go? So no, I can't, because I don't know all the facts to do a complete summary purposely, because I really don't want to get into the facts. And I see a lot of people saying you need to know all the facts before you talk about the case. That's why we're going to talk about kind of specific legal issues maybe, but not dig into the facts of the case, because as far as I know, here's the summary I know. Karen Reed accused of hitting her boyfriend cop with her car and leaving him there to die. But her story is he walked into a party with a bunch of other cops. She left and he ends up dead outside because something must have happened inside. And now there's this massive cover up. Two completely different factual scenarios and stories. From how I understand, people are telling it. I don't know what facts each side is telling. That's basically all I know about the case. If you Google it, there's tons of stuff out there about it.
My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office.
That's a logical conclusion.
Say that again.
That's a logical conclusion. I mean, that makes sense. That's the only reason they want to keep them secret.
Of a federal investigation for what his office has done to Karen Reed.
So there he said it. He is a target of investigation based on what his office did to Karen Reed. So I mean, he's saying that. I mean, he's saying the quiet part out loud, I think is how the saying goes. But I mean, he's saying it. He knows what these letters say. He's pushing for them to be public. So if the letters say the complete opposite or don't even infer this, then he's going to look like an idiot. I don't think he's doing that. I think he feels like, again, like you said, this is a logical conclusion you can make. This is an inference you can make based on these letters and other information he has.
So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right. Is there a response from the Commonwealth or no?
No, Your Honor.
Okay.
So no response from the Commonwealth there.
Which makes no sense either.
Court. Right. Like you would think you would say, Judge, we are not the target of a federal investigation.
Judge, he's a big liar. I mean, something.
I've seen these letters too, Judge. That's not what they say. That's not what they say at all. Yet they stood up and just said, well, the letters have to do with grand jury or policy, discussions, and that's why they need to be confidential. I mean, that is pretty wild. That is pretty wild. So we'll see. We'll see what kind of comes from this. Do you think she's going to let the letters be public, or at least portions of them?
I think so.
I think she should. I see people
yeah.
in the chat saying she's corrupt too. I don't know. It's the first I'm seeing of this judge. So
I think she absolutely should reveal. Those letters should be made public.
And the number one reason why I think that, just me personally, and then you can tell me your number one reason. My number one reason is because the U.S. Attorney's Office is not objecting to it.
That's a big influence for her. I mean, she can say it isn't, but what state judge is not going to say the U.S. Attorney's Office doesn't care? Who is more secret than the federal government? I mean, if they don't care, what does it matter?
Exactly. And then, then she could be outed potentially if it is very obvious that these have nothing to do with grand jury secret proceedings and things like that. Because it's pretty black and white when it's in writing in a letter. It's not a conversation.
And especially, they've been revealed to the defense. The defense has them.
Exactly.
So, make them public.
C Squire says, Peter, please thank your wife for sharing your time with us. I will make sure to do that. Why are men in my shoes? Sovereign DA citizen. I think that's supposed to be like sovereign citizen for the DA. Hi from criminologist in the UK. Cherry and Max, welcome to the membership crew. Azam, Dad, noticed your background and said, what a beautiful wallpaper on your monitor, which we can't see now that I was on before. Okay, so that's it. Anything else that we didn't hit? Whoops. That you wanted to hit?
Nope.
Okay.
That's good.
All right. So we did a random live here. Hopefully you guys enjoyed it. Sorry that there was no notice or notifications. I'm going to be back in a couple hours, probably around 3:00 to talk Chad Daybell and that withdrawal. I appreciate you all joining us here. Dad, thanks for being on with me.
Sure.
Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.